My name is Tom Altabelli. I'm a judge of Division 1 in the Federal Circuit and Family Court of Australia. On behalf of AFCC and also our partners, our Family Wizard, I welcome you to this morning's webinar, which is entitled Tough Cases, Tough Calls. I've been thinking about what to say about this topic this morning.
Me too.
I'll introduce you to our esteemed speaker in just a moment. Just some thoughts about the topic, though. You know, I'm based in Sydney, which sometimes feels like the adversarial capital of the Southern Hemisphere. We deal with tough cases, lots of high conflict cases in particular. Lots of high conflict cases where the litigants are extremely well resourced as well. And they bring a level of judicial anxiety that is greater than cases where you're assessing risk to children and trying to manage it as best you can. These truly are tough cases where tough calls have to be made. I suspect my experience is shared by many of you who are here today. And I'm delighted that we've been able to get Dr. Matthew Sullivan, PhD, as our guest speaker. Matt is a colleague and a mate. He is a legend in his own time, even though he won't admit that. He's been working in dispute resolution, family dispute resolution for decades. He was one of the pioneers in parenting coordination. He travels the world sharing his expertise and knowledge very generously. He's a former president of the Association of Family and Conciliation Courts and has a host of achievements too long to mention. Now, for Aussies, you might be interested to know that Matt is also a keen surfer. And I'm going to ask him if he can swing his camera so we can have a look at the painting that you have in your study, please, Matt. And this intriguing image is of a Hawaiian surfer. Is that right, Matt?
It is.
Yeah.
Native Hawaiian, because I like to surf in South Pacific waters more than my home in the North Pacific.
Well, thank you, Matt, for joining us. I'm going to hand over to you. Matt's going to speak for about 45, maybe 50 minutes, then we'll open it to questions, but I will be monitoring the questions in the chat box, and it may well be, Matt, that I interrupt you. But let's hand it over to you. And again, Matt, thank you so much for joining us.
Thank you, Tom, and thank our Family Wizard for co-sponsoring this with the AFCC. Welcome to all of you. Good morning. It's actually the day before in the afternoon for me in the North American Pacific. I am hoping, as Tom said, that this can be as interactive as possible. He's going to be the liaison, but do, as you're thinking about it, put your questions in the Q&A, I think is the forum, and we'll see if we can get to some of that, so it can happen as part of the flow of this. So I'm going to use a PowerPoint, which will be available to you, and they will facilitate how that happens. As Tom was saying, I'm gonna try and give you some tips, which aren't necessarily, tips can be kind of specific, try this, do that, but they can also be ways of thinking about cases that will hopefully open up for you as you go back and and try and navigate them. Some different ways of thinking and acting. We're going to talk about three topics, or actually just two major topics, and then whatever comes up in the chat, we'll try and address. Differentiating high conflict cases. You know, we often talk about high conflict divorce as sort of a monolithic set of dynamics, but I think it's important to think about different types and the implications of them. So we're going to spend a little bit of time on differentiating high conflict from domestic violence, which is another typically high conflict case that is presented in our courts, and then a notion of a different kind of conflict, a qualitatively different kind of conflict, which has implications for how to intervene in this particular conflict, intractable conflict. And then we're going to talk about mental health interventions in parent-child contact cases, even though Tom said, we don't want to cover that kind of stuff. We just cover it too much. Of course, the question that he sent me from a colleague of his, Janet Carmichael, who's the executive director of Court and Children's Services at the Federal Circuit and Family Courts, asked a question about it. So we're apparently there is more to talk about with regard to that, Tom. Okay, so let's dive in. High conflict family law cases are not a one approach fits all. So I want to give you some considerations, and I'll try to speak to, in this presentation, to mental health professionals, forensic mental health professionals, attorneys, and judicial officers, and have a little bit to say. Some of this applies to any family law professionals, but these roles have obviously different, are different and have different impacts on high conflict family dynamics. So we'll talk a little bit about each of those roles. Critically important when it comes to the presentation of a case to you in whatever role you're in, to screen and actively and in every case for domestic violence. I remember Jan Johnston, who is a colleague of mine and has written extensively for decades, in some of her studies identified, up to 40 or 50% of, quote, high conflict cases have a component of domestic violence. So that being said, every case that you may become involved in, whether it's high conflict or not, you should be screening for patterns of abusive behaviors, physical, psychological, emotional, sexual, economic, that are used to gain power over the other and maintain the misuse of that power and control of the other. These cases need to be differentiated from high conflict, which can have some evidence and manifestation of family violence. But the differentiation is about this power differential that is misused to maintain control versus what might be an escalating mutual kind of violence, which could be any of these, where there really isn't a power differential. These cases need to be screened because the principles for intervention are different for them. So I wanted to make sure the screening. There's a very robust social science literature now about domestic violence, over the last 30 years. And what's more important is it has trickled down to family court structures and processes and interventions. That isn't necessarily true with a lot of social science literature, but we're lucky in that respect because, for instance, the AFC guidelines for examining Intimate Partner Violence, 2016, is a resource if you're a child custody evaluator or any kind of assessor for how to systematically, with evidence base, look at issues of domestic violence, to rule them out, to rule them in, and to have some decision-making, structured decision-making about how to handle it as a judge or how to handle it as a forensic or an attorney or a mediator. The principle, of course, if identified, and remember that screening is a brief kind of look at whether there is evidence of domestic violence, and what follows screening, if there is evidence, is more in-depth assessment. So screening should happen in every case. Assessment obviously isn't necessary if the screening doesn't yield that kind of evidence. So when there is domestic violence, true domestic violence, interventions have to put safety first, and safety is both obviously the safety of the child, both to the potential of violent acts towards them, but also the exposure of the child to acts of violence that may be occurring and perpetrated by one parent to the other, or for that matter, any exposure in the family home. So that's a given. But what's a little more nuanced than what you need to be aware of is that even if the safety of the child is something that can be guaranteed, or at least the risk of it is manageable, that the safety of the victim, if you're going to have access by the perpetrator, has to also be assured and managed, the risk of that. Otherwise, that access should not take priority over jeopardizing the safety of the victim. I think the state of the art in terms of the assessment of intimate partner violence is the safer protocol, which the Battered Women's Justice Project, which is in the States, developed over years, and it's really very impressive. You know, we should not do screenings without some kind of instrument that guides us through in an evidence-based manner the inquiry into what the experience of people in their intimate partnership is. And it can be a screening device. It goes more in depth to assess the nature and the context of intimate partner violence. When it comes to violence, context is everything. Acts occur in a context that needs to be understood. Obviously, focusing on the effects of IPV is part of what SAFER does. And then it provides some decision making. It doesn't prescribe what to do, but it helps you think through what may be the best options when domestic violence is present, and depending on what the dynamics are, to respond to it. So I highly recommend this as a resource to you. More recently, coercive control has been a focus of social science research, and hopefully you are all introduced, if not have a fair amount of education and training in this. It's actually a tougher form of family violence to deal with in the family courts and in the juvenile justice system than abuse and physical violence, because it's a pattern of conduct that has the purpose or effect of substantially restricting the other parent's safety or autonomy through intimidation, implicit or explicit threats, or by compelling compliance. So as you can see, there may not be a discernible incident of physical violence that has ever occurred, but it leverages a power imbalance, in the relationship to be able to again, restrict the other parent's safety or autonomy. And the leverage points can be physical. And again, you may never have to engage in an act of violence, but just the implicit or explicit threat of it may be sufficient to hold that control. Emotional, certainly, what's tougher for the courts to grapple with and to deal with are financial dependency and financial imbalances that can be used to exert that control, and legal. Tom was talking about well-resourced families, and sometimes these well-resourced families have a differential in the ability to litigate that actually is a form of coercive control in the relationship, and needs to be dealt with. And another one that is particularly difficult is that the parenting and the relationship and attachment that parents have with their children can be differential, and that can be used as a form of coercive control. So many of us, myself included, in recent articles have talked about parental alienating behaviors when they're severe as being a form of family violence. They are a form of coercion and control because you have this differential imbalance in the power of the attachment with the child that's being utilized to abuse. And when we think about severe alienating behaviors in that way, it kind of changes our focus in terms of child protection and also protecting the safety issues of protecting the victim in those cases. Okay, so that's all I want to say about domestic violence as differentiated from what might be high conflict, where there's a mutual kind of power dynamics, and they could be any of these that aren't necessarily creating a power imbalance, but they are obviously very destructive and need to be dealt with in families. I wanted to talk about another kind of conflict, which is qualitatively different than kind of high conflict in the general sense, that has implications for how we think about and what the courts and mental health professionals can reasonably do to intervene when conflict has become intractable. So I want to describe that. I want to talk about the manifestation and phases of it, and I want to talk about how to prevent it becoming intractable, because by definition, once it's intractable, it's both incredibly destructive to family systems and ultimately to children, and it's also incredibly resistant to change. So I'm going to give you a brief primer in it. I will do a little promo for a book that Jack Moran and I and Sean McCall wrote that describes intractable conflict in more detail, and also talks about when it comes to parent-child contact problems, what are some practical interventions to deal with that. You'll see in the last slide some reference to this, so you don't have to put that in your chat box. So, what is intractable conflict? Intractable conflict is one that has become entrenched in cognitive, thinking, affective, feeling, and social structural mechanisms. Those are the ones that surround the system that's intractable. There is a transformation that effectively distances the conflict from perceived incompatibilities that launched it. It takes on a whole nother level of rigidity and and destruction from what actually might have started the conflict. As the conflict becomes a primary focus of each parent's thoughts, feelings, and actions, even factors that are irrelevant to the conflict become framed in a way that intensifies or maintains the conflict. You can start to feel the intensity and obsessiveness of this conflict. It is as though the conflict acts as a gravity well or negative attractor into which the surrounding mental, behavioral, and social structure landscape begins to slide. What's interesting about that is that's us and the family courts. The power of these cases kind of pulls us as the surrounding social structural landscape into the intensity of these cases. Once a pattern of thought and behavior concerning an interpersonal or intergroup relationship is established, it functions as an attractor that resists change. Very tough to intervene. So it brings up the question, once we get to an intractability place, what do we do? Because, most of think about dispute resolution. That's kind of, what we're all geared to try and effectuate with these families. That may not even be a practical or reasonable or doable goal when things become intractable. Resolution may not be possible. I mean, the intractability literature comes out of the geopolitical context, and the writers who have written and continue to write, talk about these conflicts between states and countries that have, sometimes centuries old origins. And are intractable, and how do you begin to understand and intervene? So this is an application of that geopolitical understanding and context to family systems. So Wallacher identified two patterns of behavior relative to parents in shared parenting arrangements. One is they will tend to deny or discount any and all positive information about their co-parent. Ever been there? Ever tried to say, when I was a custody evaluation, which I'm not, a very telling question in the custody evaluation was, so tell me something good about dad. And sometimes you get nothing. You get silence. Or sometimes you get some sort of mealy mouth. Well, he's a good provider or whatever. But nothing. It's a negatively polarized black image, and any kind of probing into the grays and possibly even the positives goes nowhere. Is resisted, and therefore they feel overwhelmingly resistant to acting differently towards the person they view as causing misery to their children. To again start to explore resolution, start to explore problem solving is immensely difficult. So having said that, we don't want these cases to become intractable. We've all had them. We've all failed at trying to intervene. We've all seen the collateral damage to kids and the tremendous resources that, as Tom was talking about, if parents have those resources, they bring to bear, not in any kind of resolution, but in simply the fight. So what's important about when conflict gets intractable is that, as we know, from the multifactorial models of high conflict, or for that matter, low conflict shared parenting dynamics, there's a bunch of them. And it's a highly complex system around the child that impacts that child's response, that child's functioning. We used it. I was part of the Kelly and Johnston group that developed this in 2001, which dates me now. I was the younger member of that group, who are now virtually retired. But, we put this formulation together to help begin to think about why kids reject a parent, and how we can begin to intervene. So think about that complexity, all these things that are bearing on the child and their response, and then think about conflict escalation. Because conflict escalation is not a factor like these. It is a moderating factor that impacts all of the factors. So when conflict escalation, which is defined as retaliatory escalation, which is typically driven by blame and anger, that's one kind of retaliatory escalation. I came home and you were sleeping with a contractor, with our contractor. And, I wanted to blow his head off or her head off and couldn't. I wanted to blow both of you away. And now out of anger and betrayal, I'm going to retaliate. That's the retaliatory escalation, or the defensive escalation by fear. I was, indeed a victim of some kind of family violence, and now I'm going to escalate out of the conflict, out of the fear that I continue to feel. 5 changes occur with that kind of escalation. One is the increased use of force. So when you go to an attorney, you're increasing the force in the system. When you go to the police, when you go to other sources, or when you engage with your co-parent with more adversarial, threatening force, you're using one of the mechanisms to escalate conflict. Typically, when conflict escalates, the number of issues escalate. So it's not just that you were that you threw something at me, but it's also that you drink too much. It's also that you have never been trustworthy because there was an affair 6 years ago, or you were a terrible parent. So the conflict escalation thrives and is fueled by a proliferation of issues that are brought to bear, justifying the escalation of conflict. Issues move from specifics to the more general. So now the fact that you lied to me is couched, maybe lied about a specific act, is now that you suffer from narcissistic personality disorder, or that you're an alcoholic, or that you are the fact that there was an episode or incident of violence now makes you an abuser. So these portrayals become much more general, much more pathological, and the number of parties grows. So third parties begin to get involved in these conflicts, and they tend to align and amplify. They can, if they're, and that's part of what we'll talk about, the positions of the parents who are in conflict, and that's going to escalate the conflict. And of course, the goals change from cooperation and problem solving to control and effectively, potentially, kind of winning. And in the child custody arena, the goals are often to eliminate or severely restrict the involvement of the other parent. So basically, this turns into this, which is that since it's a moderating variable, everything not only is more negative, but becomes intensely chaotic, because each factor is not going to be functioning in a positive way. If a parent's personality has some vulnerabilities, if you inject conflict and escalation, their baseline functioning is going to deteriorate. If parents have a certain level of functionality in their co-parenting and you inject conflict, it's going to deteriorate. If a child has a certain amount of resilience or vulnerability at a baseline, and they are subjected to this kind of intensity and chaos, their functioning is going to deteriorate as well. So conflict escalation negatively impacts all factors and the interaction between those factors, because this is a system. You don't want it to happen. So this is a family conflict curve, which is again about intractable conflict. And it has two axes, which is time on the one hand and intensity of the conflict on the other. And what this is useful for is that we, when I was first presenting this, we were in the midst of the pandemic. And of course, this looked a lot like the pandemic curves. And, what are we trying to do in these situations? Well, we're trying to flatten the curve, because the more amplitude that the curve has, the more intensity of conflict is occurring. And at a particular point, which is sort of arbitrary, it becomes intractable. And then it's really resistant to any change, and it's incredibly destructive to those participants who are part of it. So what I'm going to talk about here now is, what can we do as family court professionals on the left side of the curve to try and flatten it? Because there are two kinds of trajectories for high conflict. One is the case that is already intractable because of the factors that breed intractability: personality, trauma, and experiences. But there are cases that were not intractable, that had reasonably healthy co-parenting and problem solving, and then a divorce occurred or some incident occurred, and had they been handled differently as they entered the court system, they would not have climbed the conflict curve with as much amplitude, and the negative impact and the ability to indeed make have some resolution would have been much higher. So I want to spend a little bit of time talking about what we can do, both in terms of the structures of our court system and in terms of our particular roles, to not move these people who are inclined to go there anyway up the conflict curve. Because just briefly, what tends to happen in the conflict curve, as you can see at the top of it, where however high the amplitude is that these strategies that both parties have used, whether they're countries or whether they're co-parents, don't work. And the goal that they have, which is to control the other parent or to eliminate the other parent, through all of their involvement in the court system, does not work and reaches a hurting stalemate. The courts are not going to take custody away. The courts have made a determination that it will be a shared custody arrangement. Oh my God. Now what are these co-parents supposed to do? They've been spending all of their time and energy trying to vilify the other parent in order to gain control and restrict the access of the other parent, and it hasn't worked. That hurting stalemate in the dynamic is actually the opportunity. And part of the reason that this became so intriguing for me is because I've been a parenting coordinator, and parenting coordinators typically come in on the right side of the curve. Wherever the amplitude has taken them, the co-parents, you're the ones who are supposed to now make the peace. And I differentiate making the peace from keeping the peace or resolving the issues. The goals when intractable conflict has indeed set in are more limited. You are a peacemaker, and that's what I think of parenting coordination as. You disengage parents so they don't have an opportunity to conflict. Think about peacekeeping roles in the geopolitical system. They're not about getting to the root what has created the conflict. It's simply keeping the peace. And typically, and that was one of the models that I've done a lot of writing and training in. We don't move from high conflict when it's intractable to cooperative, because when we try, we engage the parents and they continue to fight. We move from high conflict and intractable to parallel, because if you can establish a structure that they cannot engage, it's a way to manage and minimize and lower conflict. And then potentially, if you can have that happen for a period of time, you might be able to start some peacekeeping, which is more about dispute resolution and more functional models of co-parenting. Tom.
Matt, can I just jump in there, Matt? The concept of the parenting coordinator as a peacemaker is intriguing. Now, you should know that in Australia, parenting coordination is still new, but it is growing, and I think it has a really, really important role to play. But I suspect that there might even be parenting coordinators in our group here today who are wondering how realistic it is for them to play the role of a peacemaker. Now, just briefly, how do you respond to that, just based on your own experience?
I think you absolutely, and again, the manifestation of the role is different. Where I practice, there is a delegation of judicial authority to me to resolve disputes. It's not essential if that's not the model in Australia, but there is a model that it is a non-confidential process that can issue non-binding recommendations or even give feedback to the judicial officer. That's sufficient. But the idea is parenting coordination is not about the resolution of custody. It's about the implementation of a parenting plan that has been mandated or agreed to, mandated by the court or agreed to. And then what parents tend to do, and that's how I first got involved. A judge in my county said to me, they're sharing custody. I've done all I can. We've done all of what we've done to determine whether, it should be, 50-50 or should be 30, 70. And these people come back to me every month about these ridiculous disputes, about summer vacation, about, telephone calls to the other parent, all these things that, everyone in the audience is nodding their head. Oh my God, and the judge said to me, if there's something that you can do to keep them out of my court, I'm all in, and I will give you whatever support you need to do that. And so, yeah, it becomes, to the extent that you can leverage your authority around an issue like, I want Johnny to be in violin versus soccer, and there's a dispute about that, to resolve disputes in a mediation but arbitration format. That's what you're doing, and that's a tremendous service because they're not going back to court, so the utilization of court resources is certainly less, and you at least have an opportunity within that format to begin to do some peacekeeping. How about if we have Johnny in violin this season, but next season, there's so much more you can do flexibly and creatively that the courts can't do in a hearing. So, that's a brief endorsement for parenting coordination, but that's why I think it's so powerful.
Yeah, and that's great. And I say, bring it on, bring it on. But Matt, what's the difference between a parenting coordinator and, say, a divorce coach? I think you refer to coaching in a short while, and it's a question that's been asked. So what's the difference? How do you use coaching over in North America?
Yeah, so let's hold that because it'll feed into some of these ways. So now what we're going to get into is how do you stop the escalation of conflict, or at least not potentiate it on the left side of the curve. And some of the flattening interventions, if you will, are obviously early interventions. But when this stuff gets momentum, it takes on a life of its own. So you want to have processes that stop the potentiation of conflict escalation. What are they? Remember, one of the axes is time. So whatever we can do quickly is better, because if there's bad stuff going on, to have that stuff go on for longer is not a good thing. So investigation and evaluation that's more rapid and focused. We talked about ruling out shared parenting scenarios, so that screening and assessment of those things that would rule out shared custody arrangements, at least for the time being, like domestic violence, coercion and control, child abuse, substance misuse, severe mental health disorders. We want to certainly identify those and have them very relevant to parenting plans. Addressing parenting plan disputes through alternative dispute resolution, which I'll talk about. Mediation, I hope, Tom, is mandated in Australia.
It certainly is. It certainly is. And another question that I got was about the appropriateness of mediation when there are domestic violence allegations. Perhaps you could circle around to that at an appropriate time, but it is mandatory in Australia.
Yeah, well, it is good that it's mandatory, because what studies have suggested is that literally 40% of the remaining co-parents who enter and begin to utilize family court services, be they the judges themselves or their family court service, 40%. So when you look at the conflict pyramid, 50% of parents never go to court. Of the 50% who remain, almost 30% of those will resolve what are their disputes that they're still struggling with through mediation. So now we're at the 80% are resolved. And in those 20%, now we have other processes that we have to bring to bear that are more adversarial, like investigations or ultimately court hearings. But mediation is an incredibly effective way to resolve disputes and to flatten this side of the curve. Domestic violence is not appropriate, or the methods that you use to mediate have to be modified to protect against an informal process like mediation, potentiating the destructive impact of the power imbalance. There's such good research now that supports what I said at the beginning of this conversation that we're having, which is every case needs to be screened for domestic violence, and if it is found, the case needs to be handled differently than if it's high conflict, and that includes mediation. It may not be appropriate at all, or it may be that it needs to be done in a shuttle format. But once domestic violence is identified, those cases should not sort of move through the same kind of set of procedures that when domestic violence isn't present. So it's a great question, and hopefully in my jurisdiction, there is that screening, and even a parent saying, I'm not comfortable mediating, which is helpful, that has to be respected. Obviously, some domestic violence victims will not say that, which is why you need to ask and you need to do some screening and hopefully, get information that you would not have otherwise gotten, that domestic violence is present in this case. So then the other parts of flattening the curve and not potentiating conflict are that psychoeducation should be something that all co-parents get as they enter the court, and orientation programs are mandated in our jurisdictions before you can ever quote see a judge. Psychoeducation is going to deal with the dumb spots that people may have, that they didn't realize and they didn't understand that their way of behaving with each other or towards their children, parenting and co-parenting were damaging. And there is a certain subpopulation of who look like high conflict co-parents who can benefit from psychoeducation. And it's cheap. So, we should be utilizing that and however, through mandates or through attorneys who are the first responders, at least when parents are represented, or court services should be freely giving out good evidence-based psychoeducation. At the end of the slides, we have Jack Moran and I also did a book about called The Co-Parenting Trap, which is all about how resistive parents and favored parents, when a child when there's a parent-child contact problem, may be engaging in behaviors that are potentiating that. And you know what? Some parents read that book and it changes everything. So we should be employing that because some folks have dumb spots, and that's a way of de-escalating conflict. Counseling and consultation are for blind spots even when you educate, people they have other obstacles, mental health obstacles that prevent them from being able to utilize that. One of the things that you saw there is that the involvement of third parties here can be something that flattens the curve or escalates it. So we need to be thinking about, as attorneys and mental health professionals, are we being polarizing or are we de-escalating conflict? And we need to think outside the box in a lot of ways in order to not just do what may be potentially okay in our particular role, but in a particular case may indeed be escalating the conflict. Yes, Tom.
Matt, can I jump in, because we've had a question relevant to this. I know I've looked at the list of people who are here. There's lots of lawyers here, lots of attorneys, lots of people working at the coalface. A few tips about de-escalating skills. So de-escalating skills, any thoughts, anything off the top of your head about what we can do to actually achieve that?
Attorneys?
Yes, please.
You have an ethical mandate, which is kind of problematic in child custody to zealously advocate for your client. I think that's the box that you're in, and that can sometimes make it more difficult, because I would argue that your goal and focus should be in the best interest of the child, but you can see where that can come into conflict. You are the gatekeepers of the system. So you set the tone for whether things are moving in an adversarial way or whether things are moving in a collaborative way. Your relationship with co-counsel, not co-counsel, but quote, I hate to even use these words, opposing counsel, is critically important in that setting of the tone. Both how you educate the client, because you are a counselor and an advocate, is going to either validate and start to, again, move these people up the ways of thinking and feeling that can be escalative, or not. Triaging to appropriate processes and services. Do you encourage collaborative processes like mediation? Tom, you asked about consultation by a mental health professional. That's the bulk of my work now. When attorneys have complex cases, they get me involved almost immediately, almost after the first consultation that they have, because they want to have someone who has knowledge and has credibility to be able to frame things for a client in a way that doesn't kind of move them in a direction of being more litigious and more and less collaborative. If the issue is I want him to move out, the tension in the house now that I've said that I want a divorce is unmanageable. There are ways to approach that. One is you without a lot of good evidence, you file a DVRO. That's a pretty nuclear option unless it's appropriate. And I see a lot of situations where it's simply a tactic to achieve a kick out. There are ways that we need to be thinking out of the box as attorneys to get that done, to have to move to separate residences in a collaborative problem-solving way. So these are some of the ideas that attorneys have. They need to know what the appropriate collaborative services are, and ideally they need to be networked with specialists, with good mediators, with good consultants, with good whatever the issues may be, so that they can competently refer their clients to those services. And that gets to mental health professionals, that court-involved treatment is a specialized practice, that if you don't have that specialization, if you don't understand, and I'm not going to spend much time on this at all, but there's a lot written in AFCC about court-involved therapy, and there are actually guidelines for it. This is a unique treatment context that requires consciousness of the impacts of that context, and it demands more specialized training and techniques. And if we don't have that, the potential to do harm is far greater than practicing as a counselor in a generalized context. So what's the message there? We need to cultivate in our jurisdictions, which is sometimes very tough if it's in a rural jurisdiction, as much specialization and training as we can. And then we need to have that interdisciplinary, those interdisciplinary relationships, so that attorneys know who the good specialists are as mediators and as family therapists and as child therapists and family therapists and parenting consultants increase their competency in this context. And that's what this movement in AFCC in particular, it's not the only place, but it certainly is a tremendous resource to develop that specialization. Judicial officers, they're the role models for authoritative parenting. They are demonstrating authoritative parenting in their courts, both with professionals sometimes, and also with parents if they're in pro per or in pro se. They have a critical role in educating and persuading parents to focus on the needs of children and harm from conflict. That's an exercise of authority, persuasion, particularly when parents know that they have that authority and can intervene in a way that could be some kind of negative consequence for behavior that is not good. And they have the authority to sort of manage the procedural direction of the case, ordering early assessment, keeping things collaborative, and ordering mental health interventions as well. So they manage the case, and hopefully they have the training and the time, because I often hear from judges they simply don't have the time to manage a case beyond hearing whatever the issues are before them. Yeah, Tom.
Matt, listen, while I completely agree with you about the role of judicial officers, I make the observation that we weren't taught that at baby judges school. We learned that on the job. But really, I wanted to say we're going to have to start wrapping up. We have almost everybody who joined us at the beginning of this webinar still with us almost an hour later. Which is a real achievement. So well done to you, Matt. But we've got 5 minutes left. Can you see what you can do in that last 5 minutes, please?
Sure. So I'm gonna just wrap this piece up, and unfortunately, I'm not going to have time to get into the last area. I think I won't do it justice if I try and work through the 6 or 8 slides that I have. So we'll have to figure out some way of maybe coming back to that. But you're right that as it relates to judicial officers, I'm going to make the case that judicial continuity and case management is absolutely critical. I think, Tom, you said to me that the courts are moving away from one judge for one case, sticking with it. That's the gold standard. Truth is the daughter of time, and I find the longer I'm with cases, the more accurate sense of the dynamics I have. I can be fooled initially, so you gain knowledge of the dynamics of the case. You gain credibility and respect of the parents if they know that they're going to have to come back to you. And therefore, you want them to have to come back to you because that's the accountability piece that's so critical to interventions in the courts. So avoiding that delay and expecting parental accountability, and also if professionals are involved in interventions, professional accountabilities is the judge's job, and so some ability to retain jurisdiction and keep on the case. And if you're not going to personally be on the case, then I think you have to have a documentation system that creates some continuity. So if a different judge is hearing the case when it's next coming up, they have the benefit of some of that knowledge from the previous judge. But the case management, not just the hearing and dispute resolution, is a function in high conflict cases that is absolutely essential to making progress and having better outcomes. And if that's not happening in your jurisdiction, you're going to have poorer outcomes. That's just the reality. So I guess that would be my final thought, because then we have this section which I apologize for not having the time to get into today, that has to do with talking about, again, navigating these parent-child contact problems.
Well, Matt, that has been amazing. As always, might I say, everyone who has registered for this webinar will receive a copy of your slides. Thank you for granting that permission. Everyone who asks will also be able to receive a copy of this recording. Matt, we've got still 358 people on this webinar. We had a total of 379 at its peak. You have managed to keep us all absolutely enthralled. Thank you for sharing your experience and expertise. And I think we'll just have to have you back, mate, and hear more about that. I'm going to invite my colleague Cassandra Solomon from Our Family Wizard. I want to